Joining me now to make sense of all of this, former DeKalb County, Georgia District Attorney Gwen Keyes Fleming, former Manhattan District Attorney Cyrus, Vance, partner at Baker McKenzie now, and an NBC News legal analyst and former FBI senior official Chuck Rosenberg. Welcome to you all. Gwen, you're the newest to my table here, so I'm going to ask you, and you're also probably the most familiar with Georgia's racketeering law. Explain why you think she felt that was the best way to try this case.
Sure. So the Georgia RICO statute is one of the best tools that a prosecutor can use when he or she is trying to tell a complex story that involves multiple defendants who did various acts towards a common goal. And that's exactly what you see here in terms of the conspiracy to overturn the results of the Georgia election. You have 19 defendants, all of whom had a part or are alleged to have a part in effectuating the fraud.
So, Chuck, you have, on one hand, I've read if it gets to trial, it's almost an easier guilty verdict than what Jack Smith's trying to do. But is it harder to get this case to trial?
If it remains at 19 co-defendants, sure, that's cumbersome. But we all know as prosecutors that that number often narrows. Mm-hmm. Many people who are indicted are better off if they plead guilty and cooperate, because there are incentives built into all of our systems to do that. So, A, if they go to trial with 19, that's a big, complex, cumbersome case. But B, I don't expect that will happen. I expect it to narrow.
There's a lot of overlap here, Cy, between federal and between her case and obviously what Jack Smith is doing. You've had some interactions with federal government. You chose to stand down and let the feds go first here. What's the dangers of her having stood down and not going forward, and what's the danger of her going forward to the federal case?
Well, I think the federal case, logically, from my viewpoint as the former Manhattan DA who had to address the Southern District of New York investigating the same set of facts that we ultimately charged the Trump organization and the CFO on, I think the January 6th case just kind of makes sense to me. Alvin Bragg, the DA in Manhattan now, has already indicated that he would stand down, or indicated he might stand down.
So you expect that. We have this trial. There's a date, but you expect that trial that he would stand down? So he'd file a motion to say, hey, we'll wait to ask for a trial until after this is done?
Well, ultimately, I think the folks who have to make the decisions here are the judges, because they're the ones. We can see how important it's going to be for these judges to maintain control over their docket and their courtroom. And I believe on the issue of how disruptive is the Trump indictment, I think the judges can control what's going on in their courtroom and security. But outside, it's a different matter.
All right, put up. We have the proposed calendar as it stands right now. Two of these are technically in already scheduled, but you have a proposed January 2nd trial for the federal 2020 case, proposed March 4th for Georgia, March 25th for the New York case, and then May 20th for the classified documents case. Of these four, the likelihood that any of them are tried before November 2024, Chuck Rosenberg?
I think it's likely that a case can be tried before November election. I think it's highly unlikely that multiple cases can be tried.
You think one?
Perhaps. But again, to Cy's point, this is going to turn on the judges and their ability to manage their dockets, the motions, discovery, and all of the other things that could crop up in cases like this. So can it be done theoretically? Absolutely. Will it be done? It's really, truly up to the judges.
And Chuck, to that point, though, it's also the judges managing Trump.
Right. And
obviously they are being very careful in terms of how they're managing his statements, and I think some of the statements are outrageous. But that's difficult than managing the docket. It's managing the external chaos.
Well, and I think that's important, too. As prosecutors, we all know part of our job is to maintain the integrity of the case and make sure that due process is filed so that if there is a conviction, that it will stand and you're not risking anything on appeal.
Let me put up a couple examples of what Trump has said on his social media platform and ask you guys whether this would normally be used as a way. Here's what he said about the judge. Judge Chutkan angrily sensing in January 6th or in October of 22, she obviously wants me behind bars, very biased and unfair. And then on a witness, Jeff Duncan, the former lieutenant governor, he's going to be testifying before that grand jury. He shouldn't. If he weren't Donald Trump, Gwen, would you expect there had been actual action against him for those comments or not?
So I think we still need to wait and see. One of the rules as a prosecutor is the case will continue to be investigated until there's a verdict. And so anything that is said that could help support charges going forward, the DA could investigate and bring additional charges. Or in a situation where a defendant has been granted bond, you could risk a bond revocation if witnesses or others feel that they're in jeopardy.
Do you expect a judge to be that aggressive, or do you think it's going to be more what Judge Chutkan did, which is, all right, then we'll start the trial in a month?
Yeah, no, I like the way she's been handling it so far. I'll say this. I think of them in two separate buckets. Attacks on judges and prosecutors, deeply unfortunate. I had it when I was a prosecutor. People attacked me. It's okay. We deal with it. Attacks on witnesses are a very different thing. Yeah. Attacks on witnesses undermine the integrity of the judicial process, in theory, if they are too scared to testify, if they're intimidated, if they're harassed, worst case scenario, if they're killed. Right. So it's a very different thing to attack a witness than a prosecutor.
Very quickly, could Mark Meadows be taken off of this prosecution list if because of the cooperation, if it's known to be a cooperation agreement with the feds?
I think that's going to be within the DA's discretion. We're all waiting to see what happens with the removal, and we'll see.
And could Trump be dropped from the case if there's a guilty verdict in the federal court, and then suddenly could you see a decision to say, all right, we'll drop him, he's already guilty?
In the Manhattan case, for example?
Or in the Georgia case?
Well, I can't speak for Georgia, but I think in Manhattan there is a question of what would be the necessity. However,
of going at him again.
My own view on that is that you cannot look to the federal government to pay attention to and to protect state interest necessarily. Yep. That was certainly my experience in the Southern District case. Yep. And I think after September 11th, New York said New York has to look after New York.
All right. This was great. I learned a lot. I hope you guys did too.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.